Good afternoon, everyone. This is Robert Lofton at McGuireWoods. We want to welcome you to our webinar entitled Big Changes Ahead for Appeals in Virginia, the New Rules for Virginia's Appellate Courts. We're pleased to have over 120 folks online, and the number is growing. What I'm going to do is I'm going to give a brief introduction and then turn it over to my colleagues, and we're going to be going back and forth talking through what Senate Bill 1261 did in expanding the jurisdiction of the Court of Appeals of Virginia. And our basic theme today is that the expansion of the jurisdiction of the Court of Appeals, which will take effect on January 1st, is the most significant change to Virginia's legal system since the Court of Appeals was created in 1985. There's a lot of details in what is happening, and it's our privilege to be able to walk through this with you. There is a function online where if you have questions, you may pose those. So please feel free to take advantage of that. We welcome any and all questions, and as we're able to, we will get to them. Next slide, please. What we're going to do today, Jenny Price in a moment will talk through, she'll give an introduction of the presenters and then talk through an overview of the courts. Then I'm going to talk about Senate Bill 1261 and the rules changes that were just approved last week by the Supreme Court. And then Matt Fender will talk about considerations for the Virginia trial lawyer. Jenny, I'll turn it over to you.
Thanks, Robert. We are very excited to have you all on with us. Robert and I are a bit of appellate nerds, particularly in Virginia, and Matt Fender is a Virginia procedure guru, or genius as I like to call him, and we've had a great time putting together today's presentation with each other, and we hope that you guys will learn a lot from the presentation today. Robert and I both do trial and appellate work both here in the Commonwealth of Virginia and across the country, but our first love is the appellate court system in the Commonwealth of Virginia. We both clerked for now Chief Justice Lemons. Back when we clerked for him, he was Justice Lemons. We were a few years apart, but nevertheless in the same clerk family. We love to talk about the cases and procedure in Virginia. And Matt is predominantly a trial lawyer. He also has a great love for the Commonwealth of Virginia, though he also practices across the country, and he specializes in commercial, environmental, and insurance coverage matters, but he has a real knack for Virginia procedure. Next slide, please. So I'm going to give a quick overview of the Supreme Court of Virginia and the Court of Appeals. Next slide, please, Matt. The overview of the courts in Virginia, this is a diagram that comes from the Supreme Court of Virginia website. And as you can see, the highest court is currently and will remain the Supreme Court of Virginia. We have 6 justices and the Chief Justice, and then the Court of Appeals is the intermediary appellate court, and it has 17 judges. Then we've got the circuit courts throughout the Commonwealth, which are 31 circuits and 120 courts. And then we have the general district courts and the juvenile and domestic relation courts. Those are courts not of record. And those will not, the circuit courts, general district courts, and the JNDR courts will not be, we will not be talking about those in great detail today, and we're not impacted by Senate Bill 1261. Next slide, please. So the Supreme Court of Virginia, this is the current jurisdiction. Its primary function is to review decisions of lower courts. It's primarily an error-correcting court. So when looking at petitions, the justices in either granting or refusing cases will be looking at whether or not there's been error in deciding whether to grant or refuse a case. So currently, there's no appeal of right unless it's from the SEC or it involves the disbarment of an attorney. All other cases have to go through the petition process. and the Supreme Court of Virginia has original jurisdiction over habeas corpus, mandamus, actual innocence, and matters filed by JERC relating to the judicial censure, retirement, and removal of judges. I'm not going to spend a ton of time talking about the justices of the Supreme Court of Virginia just because there really hasn't been much change to the court. One thing that I will highlight is that Justice Mims has announced that he will not be seeking reappointment to the bench after his March 31st, 2022 term expires, which is coming up in just a few months. The General Assembly is currently evaluating about 18 candidates that have put their name in for that appointment, and that process is underway. So other than that, the court has, the Supreme Court of Virginia has been pretty consistent since Justice Chapin was appointed in 2019. But with that one change with Justice Mims, as I highlighted, coming up in the new year in 2022. So we'll keep an eye on that. Next slide, please, Matt. The Court of Appeals of Virginia, currently the jurisdiction up until January 1st of 2022, the Court of Appeals has had an appeal as of right from final decisions from circuit courts in domestic relations matters and appeals from decisions of an administrative agency, traffic infractions, and criminal cases, and also from final decisions from the Virginia Workers' Compensation Commission. It does have a discretionary appellate process through the petition process for appeals of criminal traffic, denial of a concealed handgun permit, and certain preliminary rulings in felony cases. Those all go through the petition for appeal process. And the Court of Appeals of Virginia also has original jurisdiction over writs of mandamus, prohibition, habeas corpus, any case over which the court would have appellate jurisdiction, and writs of actual innocence based on non-biological evidence. Robert will spend a great deal of time talking to us about how that jurisdiction is going to change. It's going to be a big change, but this is how the Court of Appeals has essentially been intact since 1985. The judges on the Court of Appeals, there are 17 judges. One thing I'd like to note is that the photographs that we have both on the judges of the Court of Appeals page as well as the photographs that we had on the justices of the Supreme Court of Virginia page, I just pulled those from Googling them. That's not on the court's website. What is on the court's website is what I have on these two slides, which are the names of the judges and the senior judges. But I thought I'd spend some time going through the judges on the Court of Appeals because there are 8 new judges on the Court of Appeals, and there are 9 judges that have been on the Court of Appeals for some time. And I think that it's important to talk about the judges' backgrounds because the cases that will be going before the Court of Appeals will be heard in rotating panels of 3. So it's going to be very important to understand who your panel is, what potentially their background is, in evaluating your case when it goes before the court. And one way to do that is by understanding what the judges' backgrounds are. So I'm first going to talk about the judges that have been on the court. And the first is Chief Judge Decker. She was appointed to the Court of Appeals in 2013. She previously was with the Attorney General's office, and she also served as the Secretary of Public Safety under Governor McDonnell. The next is Judge Humphreys. He's been on the court since 2000, and he has also a background with the AG's office actually in Delaware, and then he was Assistant Commonwealth Attorney in Norfolk, the Chief Deputy Commonwealth Attorney in Virginia Beach, and he also served as Special Assistant U.S. Attorney to the EDBA, and also was a partner at a law firm in Virginia Beach, McCardle, Inman, Benson, Strickler, and Humphreys. The next judge is Judge Briels. He was appointed in 2006. He was a Chief Deputy Attorney General and was the 41st Attorney General, as well as an attorney at Christian and Barton. The next judge was appointed in 2011, that's Judge Huff, and he had a general practice at Huff Pool and Mahoney, where he did med-mal, business litigation, product liability, admiralty, and just had a general practice there as well. Judge O'Brien was appointed in 2015. She was the Assistant Commonwealth Attorney in Prince William County. In 2001, she was appointed to J&DR Judge in Prince William County, and then in 2008, she moved to the Circuit Court in Prince William County before she was elevated to the Court of Appeals. Judge Russell was appointed in 2015. He spent primarily most of his practice at various law firms in Richmond, Virginia, particularly at McSweeney, Crump, Childress, and Temple. He then became Deputy Attorney General for the Civil Division before being appointed to the Court of Appeals in 2015. Judge Attlee was appointed to the Court of Appeals in 2015. He was in private practice up until 2006, where he was appointed to the 9th Judicial Circuit J&DR Court, which covers York County, Charles City, and New Kent, to name just a few. In 2011, he was elevated to the Circuit Court, also for that same 9th Judicial Circuit. Judge Mary Malvo was appointed in 2016. She previously served as General District Court Judge in Henrico. She had also been an Assistant Commonwealth Attorney in Henrico and was in private practice in the Richmond area. And then the last judge, before I get into the 8 new appointees, was Judge Appy. He was appointed in 2019. He had previously served as Circuit Court Judge for the 26th Judicial Circuit, which covers areas like Clark, Shenandoah, and Warren counties. And prior to that, he was a member of the House of Delegates. Our new 8 judges on the Court of Appeals, the first is Judge Callens of Front Royal. She was a family law lawyer. Doris Henderson-Causey, Judge Henderson-Causey of Henrico. She was an attorney for the Central Virginia Legal Aid Office. Judge Cheney of Alexandria, a criminal defense attorney. Judge Friedman of Roanoke. He was an appellate lawyer, a long-practicing appellate lawyer. Judge Fulton of Norfolk. He was previously a Norfolk Circuit Court Judge. Judge Lorish of Charlottesville. She was previously an Assistant Federal Public Defender and had previously been at McGuireWoods as well. Judge Ortiz of Fairfax was a Circuit Court Judge in Fairfax. And then Judge Raphael of Arlington. He was a former State Solicitor General, and then he practiced law for a long time at Hunton, both before being Solicitor General and after being State Solicitor General. So those are the 17 judges on the Court of Appeals, and like I said, it is going to be important to understand your panels. They're going to be rotating with no indication of how that rotation will be working. So the panels are going to be very, very important in how Virginia law is going to be shaped and also looking at the potential outcome of your cases before the Court of Appeals. I'm now going to pass the baton over to Robert, who has spent a long time working on the rules that are about to change. He was on the Rules Committee. He is probably the most educated person on these changes that's practicing law, and so we are thrilled to have him present to us on Senate Bill 1261 and the forthcoming changes.
Well, thank you, Jenny. That's an august introduction. I'm not sure if I can live up to that, but I will try. Actually, if we could very quickly go back to slide 7. Forward 1, please. Before we begin talking about Senate Bill 1261 and the rules changes, as you think through the organization and the structure of the courts, I think 2 things are very important. One, the rules will be promulgated on or before next Tuesday, They have to come out 60 days before they take effect, and they'll be on the court's website. So one, when they come out, please don't simply rely on this PowerPoint presentation, but please read the rules. Two, I wanted to go back to this org chart real quickly. I have the good fortune of doing a lot of appellate work here in Virginia and also appeals in other states and federal courts. And the clerk's office in the Supreme Court of Virginia and in the Court of Appeals of Virginia, they're phenomenal. Enough good things cannot be said about Muriel Pitney and John Bellino. Muriel is the clerk of the Supreme Court. John is the clerk of the Court of Appeals. They're recently put in those positions. Muriel was the chief deputy. She took over after Doug Roblin's unfortunate and untimely death. And John Bellino became the clerk of the Court of Appeals after Cindy McCoy retired earlier this year. But they have a tremendous staff, and to the extent you ever have questions, you should not hesitate to call on them and their folks. If you just call the main number that's on the court's website and tell them your question, and they'll direct you to someone who can help you. Now, they very well may say that's a legal question that I cannot answer, but the offices, the clerk's offices in both courts are very user-friendly and are very responsive to both the public at large and to attorneys. So they're a great resource. So as we begin this dive into Senate Bill 1261 and the rules changes, just keep that in mind because I think in many ways they're not appreciated enough. And when you do interact with them, I think you will see, I hope I'm proven right, I trust I will be, that they will help guide you where you need to get. Let's go forward, please, to slide 13. What I want to do by way of introduction is just to give a little bit of background of Senate Bill 1261 and talk through the timing, just so you sort of understand how this process unfolded. For something of this scope, this was in the works for well over a year, actually for several years. But I think it's important that you understand the timing so that you understand how rules revisions and amendments take place. Here, this is unique in that there were a lot of substantive statutory changes that prompted the rules changes. But the understanding this, I think, will help you appreciate how amendments occur, and when you have suggestions, to go back to the point I just made, like, you should not hesitate to tee them up to Muriel and or to John because they're very receptive and very responsive. So Senate Bill 1261, the chief patron was Senator Edwards. The other patrons were Senator Surville and Senator Morrissey. It passed the Senate by a vote of 21-18, and then it passed the House by a vote of 54-45. Governor Northam signed it into law back in March, and it takes effect on January 1st of 2022, except for the provision of the election of the 6 new judges for the Court of Appeals. And that took effect on July 1st. And as Jenny's already gone through, those judges were elected by the General Assembly in August. And I did want to highlight one thing on the next slide, please. There are 8 new judges. This slide, I just included where they were from geographically because one of the rationales for expanding the number of judges, in addition to the expansion of the jurisdiction, was that the General Assembly was very intentional about bringing in more judges who would have their chambers outside of Richmond. So as you can see here, there's one judge that arguably is in the greater Richmond, one new judge that's in the greater Richmond metro area, and the others are all outside of it. And the reason the General Assembly made 6 new spots for a total of 17, but there were 8 new judges because Judge Alston was elevated to the federal district court up in Alexandria, and then Judge Petty is retiring. So there were 8 vacancies for the General Assembly to fill. And so at least for the time being, we don't anticipate any new judges on the Court of Appeals. Next slide, please. So in terms of the rationale for Senate Bill 1261, as we all know at this point, the General Assembly significantly altered the jurisdiction of the Court of Appeals to provide for appeals of right in essentially all criminal and civil cases. And why? You may be surprised to know that Virginia was the only state, prior to Senate Bill 1261, Virginia was the only state in the Union that did not provide appeals of right in criminal and civil matters. There's a lot of nuance in how each state has their appeals of right. So as we talk through these rules, keep in mind as you're practicing in other states, to always familiarize yourself with the rules of where you're going. And I know that goes without saying, but I think it's easy, especially for those of us who practice primarily in Virginia, to take a lot of things for granted. Next slide, please. Prior to Senate Bill 1261, the Court of Appeals only heard appeals in these 4 general categories. Jenny's gone through them. But the criminal cases comprised approximately 4/5 of the Court of Appeals docket. The other 3 areas, domestic relations cases, workers' comp, and state administrative agency decisions, and then were 1/5 of the court's docket. So what's going to happen now, obviously, every civil case that gets appealed, in terms of the appeals of right, there's no, people have tried to estimate how many cases are going to go up, and Matt Fender later on in our presentation is going to go over some of the recent statistics from the court. But, the Court of Appeals easily could see another 1,000 to 1,500 cases in any given year. And so that was a big reason why the number of judges were added. Next slide, please. In terms of the timing, before we dive into the rules, just so you understand it, after Governor Northam signed Senate Bill 1261 into law, Chief Justice Lemons organized a committee that was chaired by Kent Sinclair, a professor at the University of Virginia School of Law, to revise Parts 1, Part 5, and Part 5A of the rules of the Supreme Court of Virginia. I had the great privilege to be on that committee. In June, that committee released its draft to the public, seeking public comments by August 10th. Next slide, please. And the comments were assembled, and then the Supreme Court's larger advisory rules committee unanimously approved the recommended changes in September. The Judicial Council met last week on August 19th and approved the revised versions to Part 5 and Part 5A that we're going to go through this afternoon. And the next slide, please. And then that was on October 19th, and then the next day, October 20th, a week ago, the Supreme Court met and approved the versions of the amendments to Parts 5 and 5A from the Judicial Council. And as I've mentioned already, we should expect to see those rules publicly promulgated on or before next Tuesday, November 2nd, and that's in order to comply with Code Section 801-5, where rules amendments have to be distributed publicly 60 days prior to their effective date. So this is important because, and I think over the next year to 18 months, I think we will see a lot more amendments and changes in the rules. And again, both courts are receptive. So as you're prosecuting appeals, as you're seeing things that could be more efficient, more effective, to reduce redundancies, whatever the case might be, I would strongly encourage you to reach out to Muriel Pitney, the clerk of the Supreme Court of Virginia, or John Valino, the clerk of the Court of Appeals, and ask if you can just submit some public comments, because the court is always willing to hear those. The Virginia Bar Association Appellate section is another resource. I'm on the leadership for that, and you can send comments to me or Monica Monday, who is the chair of the section currently. All right, if we go to the next slide, please. I'm going to talk first about what's not changing as a result of Senate Bill 1261. I'm going to highlight some of the big things that are not changing before we dive into what is changing. Next slide, please. As anybody that's practiced in the Supreme Court of Virginia or the Court of Appeals especially since COVID, you know that both courts have strongly emphasized and have now emphatically required electronic filing of everything: motions, your briefs, the appendices, and even just letters to the court on matters. For the Supreme Court of Virginia, that's Rule 5.1b, and that actually took effect in June earlier this year. There are some exceptions for pro se litigants, for prisoners, and also by permission. You know, if there's an attorney who does not have the technological capabilities to file electronically, the court will make exceptions for that. And for the Court of Appeals, they've actually been requiring certain documents to be filed electronically longer than the Supreme Court. In many ways, they were pioneers of what both courts do. And that rule is Rule 5A1. And there's a provision there that allows pro se litigants to file by non-electronic means, and then others by permission. So pro se litigants do have the explicit capability to file paper pleadings in the Court of Appeals. Before we go to the next slide, one other thing to highlight, both courts, if you practice in federal court, you are familiar with and you probably love PACER. And if you practice in any circuit court in Virginia, you lament the fact that we do not have PACER. The Supreme Court of Virginia and the Court of Appeals of Virginia have an online system. Each website, they have a case status and information button that you can click on. It's called ACMS, the Appellate Case Management System. While unlike PACER, you're not able to get briefs. They don't have PDFs that you can download. They do have they do have boxes where you can see when the final order was entered, when the record was submitted, when briefs were filed, when decisions were rendered. So for those on the call who, like many of us here at McGuireWoods, where we parachute into an appeal, the ACMS system for the Court of Appeals and for the Supreme Court is invaluable because it's a very efficient way to see where key procedural deadlines were or were not complied with. So I just want to highlight that in terms of, in addition to the electronic filing, if you are not familiar with them, I would strongly urge you to go online and just click through on both courts and get a sense for how they record information. Next slide, please. Another thing that's not changing in the Court of Appeals, criminal appeals brought by the Commonwealth to the Court of Appeals are still by petition. And so, while the Commonwealth, there's some things that we'll talk about where they get there are some changes to their benefit in how appeals are going to proceed in the Court of Appeals. If they want to challenge something, they still have to go up by petition. Next slide, please. In terms of the Supreme Court of Virginia, as Jenny highlighted, in terms of their current jurisdiction, their original jurisdiction will remain unchanged for jerk proceedings, habeas, mandamus, and prohibition. Appeals from the State Corporation Commission, if you handle those, they still go directly to the Supreme Court of Virginia. There are very few edits to Rule 521, and I'm not even going to touch on those today. And then appeals and lawyer disciplinary matters will go up, along with appeals from a circuit court of a petition for a writ of habeas corpus. Another thing that's not changing, I know some folks there was actually attempts to amend portions of Senate Bill 1261 to change some of the assignment of error rules and the waiver rules those were shot down. As a lowly appellate geek, I was actually very glad that they were shot down because it's sort of like trying to do something without any fences or rulers or guidelines. I can't imagine how an appeal would function that way. But in terms of what is not changing, a petitioner still must assign error, and the petitioner still must indicate where in the record the error was preserved. And I've spelled out, these are the new rules that the Supreme Court has approved that'll be released publicly within the next few days. But for those of you who have practiced primarily in the Supreme Court of Virginia, and I'm going to touch on this throughout my portion here, the requirements in Rule 517 and 517 Big A, you're going to see them restated in much the same way in Rule 5A12 and then new Rule 5A12 Big A, as well as Rule 5A20. Next slide, please. All right, so what is changing? So at this point, I hope you can kind of sit back and enjoy the rest of the trip, because we're going to try to go, I want to go efficiently and do a bit of a deep dive into a couple different areas where there are some significant changes, especially for those of us who have been practicing in the Supreme Court of Virginia, and the idea of a whole new intermediate appellate process may be a little unsettling. So as we've already discussed, the biggest change and the most obvious change is the expansion of the jurisdiction of the Court of Appeals to allow appeals of right. And the General Assembly amended Code Sections 17.1, 405, and 406 that the Court of Appeals now has appellate jurisdiction in administrative matters, workers' comp matters, civil matters, interlocutory matters, which I'm going to spend a fair amount of time on shortly, and criminal matters now. Next slide, please. This is a very important point that I want to highlight before we start talking about the changes. In terms of when Senate Bill 1261 takes effect, it takes effect on January 1st. All appeals pending in the Supreme Court as of January 1st will remain in the Supreme Court. There's also a provision in Senate Bill 1261 that criminal appeals by petition that were pending in the Court of Appeals will be converted automatically into criminal appeals of right. But for the civil practitioner, this is very important. The determining factor of what constitutes pending is the filing of a notice of appeal prior to January 1st. So, for those of you who have civil cases who are going to receive a final order in the month of December, you're going to have the ability to decide whether you want to pursue a petition for appeal in the Supreme Court of Virginia or whether you want to take an appeal of right to the Court of Appeals. And so I want to highlight that for you because I think it's something that you need to talk with your clients about. You need to be thinking through strategically. We're going to talk about some timing issues about how long the appeal process generally takes in the Court of Appeals. Some of you may have clients where you want a long appeal. You don't want a final resolution quickly, or whatever the case might be. There's some tactical advantage. You want to draw this out as long as you can. Then if you get a final order in December, you wait to file your notice of appeal. You make sure you file it timely, but you wait until after January 1st. Others of you may want to be, you need a quick resolution, and you don't want to have to go through the appeal of right process. If that's the case, then you need to make sure to file your notice of appeal before December 31st.
Yeah, Robert, do you mind just highlighting? I think that's a really important practical tip for the folks on the line. So that December 1st date is an important one as far as if the final order is entered within that time period. Could you just repeat that one more time for the folks on the line? Because I do think that's a really important practical point and takeaway from today.
So if you receive a final order after December 1st, you need to think through whether you want to take an appeal of right to the Court of Appeals or whether you're going to take an appeal by petition to the Supreme Court. This is a rare opportunity where you get to decide, and there are going to be pros and cons under the facts of each case, and so I would strongly encourage you, if you anticipate receiving a final order in the month of December, you need to be having conversations with your client now so that you're not jammed up, over the Christmas and New Year's time frame, and you miss a window, to take advantage of, either you want to fast track an appeal and get it up to the Supreme Court as quickly as you can, or you may want to prolong it and go to the Court of Appeals. Next slide, please. I do want to highlight a couple changes on the criminal front. I know we have a bunch of folks on from the Office of the Attorney General, they're, in terms of what Senate Bill 1261 did, it eliminated the one-judge order, three-judge review that those of you that do criminal work have been very familiar with since the Court of Appeals was created in 1985. And so that process is gone. For criminal appeals now, importantly, and as the folks at the Attorney General's office know all too well, the Office of the Attorney General will be stepping in to handle most criminal appeals. And I want to direct your attention, I'm not going to spend a lot of time on it, but there are significant amendments in Code Section 2.2, 511, and 17.1, 407, as well as Rules 5A6, 5A12, and 5A13. And so for those of you who do criminal defense work, there are very important requirements regarding the notice that the Office of the Attorney General has to receive. And so make sure that you are aware of this, because once January 1st hits, everything is going to change very quickly. The other criminal item that I wanted to highlight is the criminal appeal bond has been abolished by amendments to Code Section 801, 676.1. Before I go to the next slide, for the civil practitioners, if you practice in other states, some states have bonding requirements, some that are mandatory, some don't. For the civil practitioners, 676.1 does not have, you don't have to go out and bond the judgment. So if you're, let's say you're a defendant and you lose a case and you're going to appeal, you need to be aware that the plaintiff can go out and execute on that judgment if you don't bond. So don't take it for granted that you get an appeal. Now that you have an appeal of right, you have an automatic stay, because you don't. So just be alert and aware of that. Next slide, please. So in terms of some kind of a bit mundane, but there's some practice points I want to flag here, changes. I want to talk first about page limits, word counts, and the signature block. If you, some really hardcore procedure geeks will understand the signature block point that I'm going to talk about. With that, the rules now for the first time clarify that the signature block does not count in the page or word limits.
Woohoo!
So this has been a long-running discussion among many in the appellate bar about, with your petition for appeal that is in the Supreme Court of Virginia that has a 35-page limit, if your signature was on the top of page 36, which you're often allowed to do in circuit courts, whether that was a proper petition or not. The Supreme Court of Virginia, and well, the Rules Committees flagged this. Our initial committee, that Chief Justice Lemons made, flagged this, and the revisions stayed through the entire process, that the signature block does not count. In terms of page and word limits, they are now throughout both Parts 5 and 5A. If you've practiced in either court, you have seen there have been aspects of the rules that, had a page limit, didn't have a word limit, or vice versa. So they're now uniform throughout. But importantly, just a practice point, go with the page limit. The page limit is much more generous than the word limit. especially if you're using a Times New Roman font. You know, both courts have acceptable fonts that they allow. There have been lots of folks that have looked at this, and everyone is in agreement. You get the most words if you use Times New Roman font and you go with the page limit. Candidly, the clerk's offices in both courts were some of the biggest advocates for page limits because that's the easiest way to see whether a brief complies with the rule or not. You know, no one wants to sit there and try to do a word count on a PDF document. So as a practitioner, if you want to get the most bang for your buck, go with page limits. And a couple examples of some new page limits that are in the rules in Part 5A. Rule 5A-12, you have 35 pages for the petition and the opposition. We're going to talk about those briefs shortly. 5A-12A, which is a new rule, it removed the old 15 and 12 page limits for petitions for review under the Injunction statute, and they're now expanded to 20 pages for both the petition and the opposition. And then 5A-19, you know, you get 50 pages for your opening and your appellee's brief, and now 20 pages for your reply brief. Next page, next slide, please. In terms of motions practice in the Supreme Court of Virginia and the Court of Appeals, I think I would say as a practitioner, I think motions practice is underutilized in both courts. The courts are receptive. You can pretty much move for almost anything, and they will entertain any motion. Now, I'm not saying that you won't get a call from someone in the clerk's office laughing at you in a good-natured way, but you have a lot of opportunity to seek relief from the courts under Rule 5.4 in the Supreme Court and 5A.2 in the Court of Appeals. Both rules require you have to certify that you've met and conferred with the other side on the motion. Importantly and interestingly, neither rule has a page limit. So I have seen really, really short motions that are 3 pages long. I've also seen motions that attach a bunch of exhibits that are over 200 pages long, and the court will entertain both. And I will say I was involved in the filing of that 200-page motion, and the clerk at the time politely directed me to Rule 14J, and so that's why I included it here, which I think is my most favorite rule in all of the court's rules, that brevity is enjoined as the outstanding characteristic of good pleading. Finally, on motions generally, an opposition is allowed to be filed within 10 days, but both the Supreme Court and the Court of Appeals are clear in their rules that they may order a shorter time, or they may decide the motion without receiving an opposition. And I've seen both of those happen. Going from motions practice generally to motions for extension, there's some very important changes in both Part 5 and Part 5A that you need to be aware of as a practitioner. One, for those of us who practice a lot in the Supreme Court of Virginia, Rule 517 was amended by Senate Bill 1261. You used to be able to get a one-time 30-day extension for the filing of your petition for appeal. I've never heard of anyone who got such an extension, but it theoretically was possible. Now the General Assembly has removed the 30-day cap and has amended Rule 517, statutorily has amended Rule 517A, and it says that an extension may be granted in the discretion of the court in order to attain the ends of justice. Extensions of time in the Court of Appeals also may be granted, and the General Assembly used this phrase, in order to attain the ends of justice. I don't want to talk about that in a moment. That's the phrasing that the General Assembly used, and the timing of when an extension request in the Court of Appeals is due is a bit ambiguous. Rule 5A.3c spells out that a motion for extension of time is timely if either it's filed within any specific deadline governing a motion to extend, like Rule 5A.8, 5A.13 has some specific deadlines when a motion for extension has to be filed, or and I just quote the language from 5A3, if a rule does not provide a specific deadline governing motions to extend within 30 days after the filing deadline from which an extension is sought. So as a practitioner, what I would tell you is don't ever need to be in a position where you have to seek an extension. There's some ambiguity because Rule 5A3B also says filing a motion for extension does not toll the applicable deadline. So you could be in a situation where you seek an extension and whatever grounds you have asserted, the court doesn't find them meritorious. And then you're going to be out of luck. And importantly, if we go to the next slide, I just touched on this a moment ago. Senate Bill 1261 uses the phrase, when talking about extensions, in order to attain the ends of justice as the standard for determining whether to grant extensions. This is already the subject. This is what went through, what the General Assembly passed, what the governor signed, and what's in the rules right now. But this is already the subject of a potential legislative amendment in the upcoming session because especially those of you who do criminal work, you know that the ends of justice exception is a hard exception to meet. And so I cited two cases there, one from the Supreme Court, one from the Court of Appeals. The Supreme Court says we apply the ends of justice exception in very limited circumstances, usually if the result is going to be a grave injustice. And the Court of Appeals has similarly recognized that it's narrow, it's to be used sparingly. So the legislative amendments that have been drafted are going to say, are going to just go to a good cause standard and leave it to the discretion of the judges or the justices. So be on the alert for that. Next slide, please. In terms of how appeals of right, I want to talk for the next bit about appeals of right. And again, for those of us who are used to Supreme Court practice, how things are going to be noticed and briefed in the Court of Appeals is different. And you need to make sure you familiarize yourself with these changes. For an appeal as a matter of right, Rule 5A16 is the beginning point in Part 5A where you need to look. Importantly, once you file a notice of appeal in the circuit court, no petition for appeal is filed in the Court of Appeals. Instead, the subsequent briefing schedule is based on when the record is filed with the Court of Appeals. And I put myself in this camp. For those of us who are not used to this and are used to being in the Supreme Court of Virginia, this may sound very unsettling. But I can assure you and tell you that the Court of Appeals has a phenomenal process in place where when a record is transmitted from a circuit court to the Court of Appeals, the Court of Appeals usually within 24, at the longest 36 hours, will send a notice out to all counsel of record because it receives that information from the circuit court saying the record has been filed. And in the notice, and this notice now comes out electronically, so you don't have to worry about any inconsistent deliveries with the U.S. mail. It comes out electronically, and it will direct you to the rules. It also will give you a brief overview of when your deadlines, your upcoming deadline, what your upcoming deadlines are. So the Court of Appeals has a great process in place, but you need to be alert to the fact that your merits briefing is all hinged on when the record is filed, and it's not the same time frame that we have seen in the Supreme Court of Virginia. Importantly, as an appellant, even in an appeal of right, you still have to assign error. We're going to talk about that because there's some new wrinkles about when those assignments of error are due, and you have to note where those assignments of error were preserved below. Next slide, please. So with the joint appendix, and this goes to the assignment of error point that we just talked about, there are two significant aspects of Rule 5A25 that every practitioner has to be aware of. One is generally, and this is a sea change in Virginia practice, a joint appendix no longer will be required in cases where the clerk of the trial court or other tribunal files the record electronically with the Court of Appeals. So the new rules that you will see, they have an advisory note. There are approximately 10 circuit courts around the state that don't, as a general rule, don't transmit records electronically. So as a practitioner, especially whether you're handling a case and you know you're going to do the appeal, or you're jumping into a case, perhaps even more importantly, if you're jumping into a case on appeal, you need to find out very quickly how the circuit court is transmitting the record. One, you need to get it. You need to know how easily it's going to be accessible. But two, the filing of that record is going to determine all of your subsequent deadlines. Next slide, please. The second point about the filing, about the joint appendix, one, it's not going to be required if the record is an electronic record. Two, for those of us who've been in the Supreme Court, this may shock you. Within 15 days of the filing of the record, you have to designate your assignments of error. We're all used to designating the contents of the joint appendix within 15 days of an order granting an appeal in the Supreme Court. But now in the Court of Appeals, you have to designate your assignments of error. This actually has been the requirement in the Court of Appeals under Rule 5A25. There was significant discussion about whether that would continue, and the committees all agreed, and the Judicial Council and the Supreme Court agreed that's going to be the rule. So, as a, I know we have a lot of civil practitioners on the phone. You have to be aware that you cannot wait to the filing of your opening brief to sort of sort through your assignments of error and talk with your client, talk with your trial team. You have to be ready sooner now, and that's something that gets filed with the court, and you serve on the opposing counsel. And so everybody's going to be on notice before the opening brief gets filed about what your assignments of error are.
And Robert, another practical point would be if you're going to get appellate counsel involved, it would be beneficial to do that before that 15 days where you have the assignments of error.
Oh, yes.
Yes.
Yeah, because that, that would be, that gives me heart palpitations now, thinking about stepping into a case where someone has already designated my assignments of error and I'm stuck with them. So next slide, please. In terms of the timing for civil merits briefs in the Court of Appeals, Senate Bill 1261 spelled out the criminal deadline. It's a 40-day deadline to file your opening brief. Senate Bill 1261 was silent on the deadline for civil appeals. So this was discussed at length in Rule 5A19. It's now a 40-day deadline to file your opening brief, which, as you folks who practice in the Supreme Court know, is the same requirement. And generally, just statistically on average, a record has been filed in the Court of Appeals within 80 days of the final order in the circuit court. As folks who practice in the Supreme Court know, by statute, the record has to be filed in the Supreme Court within 90 days. So we probably should expect to see that 80 to 90-day window still to be the case. But, again, be alert and be mindful and aware of when the record gets filed. Next slide, please. Here is a chart that I put together just to kind of highlight the timing differences. So there's, on the column on the left, you have pre-Senate Bill 1261 timing in the Supreme Court of Virginia, which, for civil practitioners, this is where you've mostly been. And then on the column on the right, I have post-Senate Bill 1261 timing in the Court of Appeals for civil cases. The deadlines are roughly the same for criminal cases, but I wanted to kind of, for space purposes, focus on civil appeals. And as we talked about, starting January 1st, 15 days after the record is filed, or 15 days after the granting of a petition of a discretionary appeal, you have to file your statement of assignments of error. And then 40 days after the record is filed, you file your opening brief. This is an expansion of 5 days from the Supreme Court rules. The appellee now has 30 days to file their brief and then 14 days for the reply. Importantly, in the Supreme Court, the 40, 25, 14 time frames and 526 are going to stay the same. So for those of you who are going to be practicing in both, you need to recognize they're similar, but they're slightly different briefing schedules. So for the appellee, don't get caught in the situation where, you know, if you're in the Supreme Court, you think, oh, I had 30 days, when in fact you have 25. And as you know, if you fail to file your brief, you can't argue in the Supreme Court. Next slide, please. A few more notes quickly on merits briefs in Rule 5A-19. Request for extension. You know, I think for many of us in the Supreme Court of Virginia, you can't ever imagine asking for an extension, but Rule 5A-19 allows a request for an extension of time, and it must be filed no later than 10 days after the expiration of the deadline. So you theoretically could blow your deadline, file a motion for an extension, and I would say from my perspective, I sincerely hope you have a great reason, because simply asking for an extension does not toll the deadline. So again, if you don't have a good reason, you could be out of luck. And then importantly, in 5A-19E, the Court of Appeals has explicitly prohibited arguments made by reference. And so, you know, merely citing to briefing below and trying to incorporate it is not allowed. Next slide, please. I want to talk real briefly on injunction and interlocutory appeals because not all civil appeals are appeals of right under Senate Bill 1261. And for those of you who have cases where you're seeking injunctive relief, or you're opposing it, or there's an interlocutory issue, I would direct you to Rule 5A-12 and new Rule 5A-12A. Senate Bill 1261 made several distinctions in how appeals under Code Section 801-626 and what will soon be old Code Section 801-670.1, which has now been recodified as 801-675.5. The General Assembly split, so you have the injunction statute in 626, and then you have, you know, what many call the interlocutory appeal statute in 670.1. The General Assembly recodified it in 675.5, but split up how the cases are handled on appeal. And importantly, for injunction and interlocutory appeals, a notice of appeal is not required. You simply go, and you'll see in a moment with the deadlines that you have. You don't want to waste time having to worry about a notice of appeal, because you need to get up to the Court of Appeals. Next slide, please. For interlocutory appeals of certified questions of law, that's old 670.1A, where you ask a circuit court to certify a question of law to the Supreme Court of Virginia. That's now recodified in 675.5A. And then injunction appeals, which also now includes old 670.1B. That's the petition for review process that many of us are familiar with in Rule 517A. Next slide, please. So while almost all civil appeals are appeals of right, Senate Bill 1261 split them up, and under Rule 5A-12 for certified questions of law, no oral argument is going to be allowed on these petitions for appeal, except for the Commonwealth, and there's some specific exceptions allowed for the Commonwealth. Next slide, please. And then under the Multi-Claimant Litigation Act, if you're seeking an appeal there, you have to file within 10 days of the order you're challenging. For interlocutory appeals seeking a certification of a question of law, you have to file within 15 days. The deadline to respond to both was silent in Senate Bill 1261. The court has decided under amendments to Rule 5A13 that you have to oppose each of those within 7 days. That's the default. Although, again, going back to the discussion of motions practice, you can ask for an extension of time. But just keep in mind, given the fast nature of injunction and interlocutory appeals, that request may not be granted. As is the case, currently the Court of Appeals, as is the case in the Supreme Court, the Court of Appeals may grant without receiving any opposition. Both the petition and the opposition under 5A12 can be up to 35 pages, and no reply brief is allowed. So if you're a petitioner, you have one shot. But if you're seeking an appeal under, I'm just going to call it 670.1A, you do have the opportunity for rehearing. You don't have it under the next slide, under Rule 5A12A for injunction appeals. What the Supreme Court has decided is you cannot, and the General Assembly put this in Senate Bill 1261, you cannot seek rehearing of a petition of an injunction appeal under 626 or 675.5B, but you still have the opportunity to pursue an appeal in the Supreme Court under Rule 517, capital A. And yes, I know there's lots of capital A's flying around, and so you just have to take the time to read the rules and familiarize yourself with them. Importantly, under injunction appeals, the petitioner now is affirmatively required to serve the respondent the same day the petition is filed, and they have to do so electronically, and they have to certify to the court that they've done so. I think the courts recognize, one, the technology is there. Two, these injunction appeals normally are, if time is of the essence, and if you throw a brief in the mail, the U.S. mail, it may take 2, 3, 5, 48 days to get there, and the respondent has lost the window to oppose it. The respondent is allowed to file a response, but as I've already talked about with the other Rule 5A12, the Court of Appeals may shorten the time to do so and may decide it without receiving a response. Next slide, please. And a couple other quick things on injunction and interlocutory appeals. For injunction appeals, if the order being challenged has an injunction aspect to it and other things that don't relate to the injunction, the Court of Appeals is allowed to bifurcate that and only address the injunction issue. So that's important for the practitioner. If you get an order that gives you, if you're challenging an injunction, let's say the order sets an injunction in place but also orders some other relief, you're still able to take that up on appeal. And the Court of Appeals will just cut out whatever is not included and will focus on the injunction. Under Rule 5A12A, as we've already talked about, the petition and the opposition is limited to 20 pages, no reply brief, and rehearing is not allowed, but you do get to go up to the Supreme Court of Virginia under Rule 517A. Next slide, please. In terms of oral argument in the Court of Appeals, there's some significant changes. Currently, the Court of Appeals may dispense with oral argument in civil cases through summary disposition when all the judges on the panel, quote, conclude from a review of the record and the briefs that the appeal is without merit. That's the key phrase, without merit. Next slide, please. Now, the General Assembly in Senate Bill 1261 has amended 17.1403, and these amendments have flowed through to 5A27. And now the Court of Appeals may dispense with oral argument only when the panel says the appeal is wholly without merit, or, and this is the key practice point, when, quote, the dispositive issue or issues have been authoritatively decided and the appellant has not argued that the case law should be overturned, extended, modified, or reversed. So if you have a case where you're worried that you may not get oral argument, where you're going to take an appeal of right, but you think it's important to get oral argument. You need to think through how you're going to frame your argument and whether you in good faith can say the case law should be overturned, extended, modified, or reversed. And importantly, this limitation applies to any matter, so both criminal and civil now. Next slide, please. I want to spend a little bit of time talking about rehearing and en banc review in the Court of Appeals. It's a little bit different. I won't go through the federal rules and how it works in the Fourth Circuit, but there are some differences. So, just if you're going to be in the Court of Appeals and you're going to seek rehearing or en banc review, look at Rule 5A33, 5A34, and 5A35. Next slide, please. We'll go through these in just a few minutes. So rehearing from a panel decision, you have to file your petition for rehearing within 14 days. It's limited to 25 pages. No opposition or response is filed unless the Court of Appeals requests one. And there's no oral argument. So, and the grounds for granting are very straightforward. One member of the panel who decided the case adversely to the petitioner must determine, quote, that there is good cause for such rehearing. That's the only standard that is given. So it's within the panel's discretion. And you just have to convince somebody that decided against you that there's good cause. If it is granted, then a response, what Rule 5A33 calls an answering brief, is allowed. It's limited to 25 pages, and it has to be filed within 21 days of the order granting rehearing. And then it'll be placed back on the docket for a second round of oral argument. And interestingly, I want to flag this for you, especially for those who are in the Supreme Court. If it's granted, and let's say the respondent, you're like, I'm not filing another brief. My client doesn't want to pay for it. This is silly. I've won. I'm going to win again. The rule says the respondent may be heard orally whether or not an answering brief is filed. So you have a window on rehearing where you don't have to file. You don't have a conversation with your client. It may not be worth the time and the money to file the same brief you've already filed. Next slide, please. In terms of en banc review, Rule 5A34 reinforces the requirements in Code Section 17.1 402D. And as amended, this is important in terms of understanding how the en banc process is going to work now in the Court of Appeals. There are three ways to get en banc review. The first is there's a dissent in a panel decision. The aggrieved party asks for en banc review, and 6 judges on the Court of Appeals vote in favor. That's option 1. Option 2, when any judge on the panel shall certify in his opinion a decision of such panel of the court is in conflict with a prior decision of the court or any panel thereof, and 5 judges on the Court of Appeals vote in favor of en banc review. So think through this from a practice point. You may want to tee up your appeal of right, your merits briefing, so that you tee it up so that even if you lose at the panel level, one of the judges says, hey, we need to have en banc review. Or the third option is the Court of Appeals, on its own motion, at any time or upon the petition of any party, in any case in which a majority of the court determines it's appropriate to do so. So that's sort of a catch-all that gives the Court of Appeals the ultimate discretion about when and whether to grant en banc review. When the Court of Appeals sits en banc, it has to have at least 13 judges to sit. Next slide, please. And when you seek en banc review, you have to file your request within 14 days of the order at issue. Your brief is limited to 25 pages, and no answering brief is allowed unless requested by the Court of Appeals. Next slide, please. And last slide on en banc review, if it's granted, Rule 5A, 35B, and as a procedure geek, this kind of appeals to me because the idea of getting to argue in front of this many judges is both a little bit exhilarating and petrifying. And so the Court of Appeals can grant en banc review in whole or in part. Only the issues that are granted can be briefed and argued. But interestingly, the party who was the appellant will file the opening brief, whether or not they were the requesting party for en banc review. And then the appellee files its appellee's brief, and then the appellant gets a reply. The court could alter that if they wanted to, but that's the default in the rules. And then the case is put back on the docket for oral argument, and you go around again. Before I transition to Matt with some practice points for the trial lawyer, I wanted to walk through a few questions and considerations for the appellate lawyer and give you a brief overview of the upcoming schedules for both courts. Next slide, please. I've gotten this question from a lot of folks. You may have wondered it as well. In looking at the statistics, and Matt will go over these a little bit in terms of just caseload, but generally, the question I've gotten from a lot of clients is how long is it going to take from circuit court final order through Court of Appeals to Supreme Court, from start to finish. It's not entirely clear. We don't have statistics, but a good ballpark is it'll be around 3 years. If you go through every stage of every process, like that is probably the longest it's going to be. But hopefully within another 18 months, we have some figures that can answer that question. Next slide, please. This is, I've had two folks ask me this question. Can we just skip the Court of Appeals? So theoretically, the answer is yes. Code section 17.1409 allows for certification of an appeal to bypass the Court of Appeals and go straight to the Supreme Court. But this can only be done if the case is of such imperative public importance as to justify the deviation from the normal appellate practice, or the docket or status of work on the Court of Appeals is such that sound or expeditious administration of justice requires that jurisdiction over the case to be transferred to the Supreme Court. If you look at 17.1409, it looks like this skipping of the Court of Appeals can only be done by the Court of Appeals in the Supreme Court. It's unclear. I've asked around and at the courts, and I'm not aware of any motion by a party asking to skip the Court of Appeals. So theoretically, you could file such a motion. I don't know what the Supreme Court or the Court of Appeals would do with it, but if you do file such a motion, I would love to hear about it because my inner procedure geek is very curious. And then before we go to the schedules, in terms of the changes, the amendments to 17.1410, with Senate Bill 1261, the General Assembly removed the requirement in 410 that a petition for appeal from the Court of Appeals to the Supreme Court must involve a substantial constitutional question as a determinative issue or matter of significant precedential value. The writ panels that the Supreme Court had earlier this year, they had this very issue come up, whether under 410 the appeal qualified. And one of the discussions at the writ panel was, well, what do we do about this knowing that this code section actually has already been amended? And to my knowledge, no order has issued yet on whether that appeal is going to be granted. But so that requirement is out. And so now, because you have the appeals of right to the Court of Appeals, you're going to be able to just tee up your appeal to the Supreme Court. Importantly, under 517A, like the key deadline you need to know is you have to file your petition for appeal within 30 days of the decision of the Court of Appeals. And so, if you are someone who has handled workers' comp or administrative agency cases or domestic relations cases, you have a new opportunity to seek appellate review in the Supreme Court of Virginia, because you don't have to certify that it involves some sort of substantial constitutional question. So it will be interesting to see, in 18 months, once we get some statistics from the court, how many of these cases the Supreme Court is granting.
Robert, we do have a question about that.
Certainly.
And the question that came in is, how does the timing for rehearing or en banc in the Court of Appeals relate to a further appeal to the Supreme Court, if at all?
So that's a great question. Thank you very much. You can go either route. You can, because if you seek a petition for rehearing in the Court of Appeals, then it's still the jurisdiction is still with the Court of Appeals. So if you want to prolong your time in the Court of Appeals, seek rehearing of the panel decision, and then you can seek rehearing en banc, and then you can seek an appeal in the Supreme Court of Virginia. So you can stretch it out, or if you don't like the panel decision, you think it's awful, for whatever reason, your client says, let's go on up, you have 30 days from that panel decision to get your petition for appeal filed in the Supreme Court.
But to make sure that's clear, the 30 days doesn't start to run until the final action from the Court of Appeals, whatever that may be.
Yes. But thank you, Matt. That's a great question. But if you know you're not going to seek rehearing, and you know you're not going to seek en banc review, that 30 days runs from the date of that panel decision. That's how you need to calendar it in your head. And real quickly, before we transition to Matt, in terms of the upcoming schedules for the Supreme Court and Court of Appeals, I included these for a couple of reasons. Go to the next slide, please. When I cut and pasted this, we still had the writ panels last week. So the Supreme Court, they had their November session. They slid it back a week. And then they have writ panels on December 7th. And that's it for the rest of this year. Next slide, please. And then for 2022, they're going to follow, for those of you who follow the Supreme Court, this is the same calendar that you have seen for a long time. And what they've done, you may see on August 31st and September 1st, they have 2 days of writ panels. Their summer writ panels. The last few years, that's been down to 1 day. So it's very likely, if you're thinking through the timing of when you might have your writ panel, very likely one of those dates could disappear based on the docket and the caseload. But that's its normal schedule. Next slide, please. For those of you who have not seen the Court of Appeals, have not been to an argument, I would encourage you to go. As Jenny talked about, and I'm sorry, when I put this together, I know the font's kind of small. The Court of Appeals sits in 4 panels in 4 regions. And so here's the schedule for the remainder of this calendar year. The locations change every panel, and normally they sit in circuit courts. And so, in Eastern Virginia, they may sit in Chesapeake, they may sit in Norfolk, in Western Virginia, that'll go, that can go all the way out, to the southwestern part of the state. And they'll sit in a variety of circuit courts. Here in Central Virginia, they'll sit in the Court of Appeals building. They may sit, I think it goes almost up to Fredericksburg. But so if you're interested in going and seeing what it's like, just call the clerk's office and find out where they're going to sit. They'll distribute that information to the public a few days beforehand. And then the next slide, which will be my final slide, this is only the schedule for the first 5 months of 2022. What you can see is the Court of Appeals is already anticipating an increase in the caseload. They are going to be having panels meeting 4 times a month. And then they've already set aside some en banc time as well, anticipating requests coming in. I know there are a couple of en banc cases pending right now. So, it's just really encouraging, somebody who has to sit with a client and kind of think through timing issues. The Court of Appeals is already ready. They have their new judges. They've significantly increased their clerk's office. They've increased the attorneys in the chief staff attorney's office, and they're ready to go. And so I think the next few months will be exciting for the appellate community in Virginia. The last thing I'll say before I turn it over to Matt is expect a little bit of confusion, some chaos. Be patient with the clerk's offices as you talk to them. They're trying to sort all this out too. And I think to the extent you have questions and suggestions, raise them because they're receptive.
Robert, before we pass over to Matt, do you mind talking a little bit about how both courts, the Court of Appeals and the Supreme Court of Virginia, are handling COVID protocols as far as telephonic hearings, in-person hearings?
The courts, thank you, Jenny, and I know we're on the telephone, and I'm smirking because I'm a big, the circuit courts are open, and I look forward to the day when the appellate courts are open too. Right now, everything is handled, writs are handled telephonically, merits arguments are handled by Zoom. So hopefully after January 1st, when we have this expansion, we go back to in-person arguments. But, I would expect to see changes in that, I hope, in the next few weeks. I do know some of the Court of Appeals panels have been in person, depending on where they are. Okay. But everything in the building up on 9th Street, no arguments are happening in the building. So with that, I'll turn it over to my colleague and friend, Matt Fender.
Thank you, Robert. Well, that is an incredibly hard act to follow, so I'm not going to say very much, but I did wanted to try to wrap this up with a few points for the practitioner at the trial court level. We might call SB 1261 the Full Employment for Appellate Lawyers Act because it's certainly going to generate a lot of appeals, and that is going to have some serious impact, I think, on our strategy, client counseling, and the approach we take at the courts below when we have the matter in litigation. So I think the first point is that it is definitely likely to create a much more robust body of law, particularly civil law. So since 1985, we've had the Court of Appeals, creating criminal law, and there's now a fairly robust body of criminal cases from the Court of Appeals. But our civil cases forever have been limited to what comes out of the Supreme Court of Virginia. At least according to Lexis, we have decisions from the Supreme Court of Virginia from 1730 on. But there have never been a lot of them in any given year. So I put on this slide some numbers that I got from the Supreme Court's website. The latest statistical report that was up there was from 2017. But as you can see, if you look at 2013, 2014, 15, 16, and 17, with the exception of a slight bump in 16, they're hitting right around 80 cases a year. It goes up to 95 in 16 that they're granting. And then you can see it looks like cases that are refused, sit around 350, something like that. But so what that effectively tells you is you're getting in the neighborhood of 80 decisions from the Supreme Court in both criminal and civil matters. So compared to other states, other jurisdictions, and I practice a bit in New York, where you have a very robust body of commercial and civil law. I handle a lot of contract cases, insurance cases, things like that. As soon as in Virginia, our law is a little thin, and you frequently find yourself either arguing by analogy or resorting to the law of another state, a sister jurisdiction, dealing with issues of first impression. So I suspect a positive thing that's going to come out of this change is that, 10 years from now, we're going to have a lot more law in Virginia, and we're going to have a lot more certainty. So when we advise a client or argue into a circuit court judge, we'll have more to rely upon, and the law will be robust. And I think that will be helpful. I do think, though, in the short term, we're also going to find ourselves with a lot of uncertainty. We're going to have, a lot of new decisions that are coming out. We're going to have the Court of Appeals interpreting prior cases from the Supreme Court of Virginia. I imagine we can have some conflicting panel decisions from the Court of Appeals, or at least ones that we lawyers can argue are conflicting. And so I think there's going to be a little bit of happy chaos, perhaps, as this starts to develop. So I think in the coming years, as this is happening, we're going to have to all go to a lot of CLEs, read a lot of appellate decisions, and be careful to follow what are likely to be some significant developments in civil law, particularly commercial law in Virginia, because we're going to have a lot more judges looking at those cases and reviewing them and issuing decisions. Second big point is how is this going to affect settlement strategy? As most of you on the phone, I'm sure know, the overwhelming majority of cases are resolved by settlement, whether before or even after trial. It's fairly rare to have a case that doesn't settle in at least some form. As it stands, if you don't like the way your case came out in the circuit court, you can petition the Supreme Court of Virginia for review. You'll get a writ panel. Your petition will either be granted or it won't. If it's not granted, it wraps up maybe somewhere in the neighborhood of about 6 months, maybe a little more. If the appeal is granted, maybe it takes 18 months at the outside. Again, it could be a little longer, but you're going to reach some final resolution there. And even if there's a petition for rehearing, it's just not going to go on all that long. The prevailing party can, be confident that the end is at least in sight. As Robert has just explained to us, under these new rules, this can now go on literally for years. Assuming that there's something to appeal, the losing litigant can go first to a panel of the Court of Appeals, could then seek rehearing, could then seek en banc review, could then go to the Supreme Court, could then conceivably seek rehearing in the Supreme Court. So if you are the prevailing litigant, you're going to have to consider the implications of that in deciding how and whether to settle with the party you just beat in the circuit court. And even if you haven't gotten to trial yet, if you're just in the the discovery phase, your motion practice phase of the case, you're going to have to consider that the threat to go to trial and win at trial is going to be tempered a little bit by the fact that the other party can still tie you up in court for years of appeals. Now, obviously, a losing litigant is going to want to maximize the value of that appellate right. You can walk up and say, okay, yeah, you got your jury verdict, judgment's been entered. How about settling for less than the full amount, and we'll waive our right of appeal. So I think that's going to be a significant thing that's going to come up in mediations and at the negotiating table. It's perhaps an unintended consequence of these changes that getting justice is going to take longer than it used to in many cases. So finally, as Robert has addressed, and contrary to popular belief among non-lawyers, an appeal is not just a do-over because you don't like the way the case came out, right? You have to point to an error. You have to assign error and point to something that was wrong. There's obviously ethical considerations for lawyers on that point. We can't file frivolous appeals just so we can't file other frivolous pleadings. And I think for the trial court practitioner, one thing to consider is facing the fact that the other side now has an appeal as of right. Do you really want to win that aggressive evidentiary ruling, or really get that jury instruction that you put in that the jury's probably not going to read anyway, but which is going to give the other side a great point of appeal? So thinking carefully as you prepare for trial, as you go through your pretrial conference, you start dealing with those rulings and the ones that are made during the trial. Thinking about the fact that appeal is looming, and there's going to be an appeal for sure if the losing party wants it, I think it's going to make all those things more important. It's therefore, again, probably important, and this is actually on my next slide, but I'll say it now, to get your appellate counsel involved early if it's a significant case. If it's a big case to your client, if it's worth spending the money, and if you, the trial lawyer, are not well-versed in how these things work, being advised by somebody who is early on could be a big deal. Obviously, again, knowing that, let's say you lose, you're thinking about preserving that right, being very careful to preserve your points of error is, again, going to be critical. Note your objections on the record. Note them when you endorse orders. I am fairly adamant that I always bring a court reporter to court. I know some people don't, but I find the cost of it is well worth it. Show up with a court reporter, buy the transcript, have it in hand, because you may be very glad you did later. And as I said earlier, have your counsel present at trial. So that is what I had. Jenny, Robert, anything else?
Well, this is Robert. I know we're at the witching hour. I know we've gotten a few questions, several that I've responded to on the phone, several that we've responded to electronically. To the extent, well, one, thank you for being here. We, as Jenny said at the beginning, we love Virginia practice and procedure. To the extent you have other questions, please feel free to reach out to Jenny or Matt or me. We would be delighted to talk with you and answer anything that you might have. We will be circulating the slide deck and also the CLE information as well, just to anticipate those two questions that you might have. But again, thank you very much for giving us some of your time this afternoon, and we'll look forward to another time to talk about good old Virginia civil procedure. Thanks.
Thanks, y'all.